Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Go into New York, where we have, this is just preliminary stuff, and I'm not sure. I mean, there's interesting stuff here, but I think for viewers, what we're going to talk about is, hey, what does this mean? So we have they're called a lot of things: protective orders, anti-spoliation orders, right? Evidence preservation. And I want to talk about that with people because these are common. But normally the first act when and I'll give the facts in a moment, but normally the first act when a lawyer takes in a lawsuit and has questions and wants to make sure evidence doesn't get destroyed, videos, reports, right? All of this, they send a you can, again, call it whatever you want, but preservation, and a lot of times these are electronic preservation notices, preservation notices, whatever they are, they say, don't destroy anything. If it affects this, if it even possibly affects it, don't destroy it.
We call it evidence preservation request.
Preservation request, right? And there's a civil practice law and rule, civil procedure in New York that we use, and we just...
Oh, Brad, I just lost your volume. Just lost your sound. Brad's at home today, so no. I can see you.
You can see.
It just
now?
Came on.
Hold on.
Yep, we got you.
Okay, so wait. Okay, so I'll try to hold. So what we have here is we have a woman whose a woman's fiance and two children were severely injured in a gas explosion in Keemesha Lake in September of 23. And she filed a petition to order her landlord, the propane supplier, the local fire department, interestingly, to preserve evidence. Now, fire departments would never get rid of evidence, right? It's a criminal arson issue. Whatever.
Oh, yeah, we would never. Yeah.
We would never, no. But nonetheless, so what she's claiming here is obviously there was something that happened. There was a gas malfunction that caused the explosion because the home was just serviced. And she wants preserved, her lawyer wants preserved some really interesting things, right? Like soil samples, which I think is really interesting, but good for them. They're going to spend some money on experts, but good for them. So, they want soil samples. They want things about tanks and any pictures, audio. This is basic stuff. But when you receive it, people act one of two ways on these. And I want to be clear, your way you react isn't to try to start finding stuff and shredding it, right? So this comes with criminal consequences if you destroy these preservation notices. So don't, is my only point for this, I guess.
Yeah, this interests me, and I thought it'd be interesting to everybody to understand that this goes on. And a lot of times we don't realize, especially if you're on an engine, a ladder, or an EMS unit, you're totally unaware that these things are going on after we go to the fire, we put it out, we leave the scene, we go back, we get ready for the next one. But this is the kind of stuff that happens. And when I was at the NFPA, there was a fatal fire in Warwick, Rhode Island. And one of the attorneys, and this was, I was doing fire law blog back then. There was no vlog or anything of that nature, but it interested me. So I reached out to the attorney, and I don't know if we did a podcast or not, but I thought it was such an interesting thing because it was a fatal fire. And he immediately, like the day after the fire, put in a similar petition under Rhode Island law. We can do basically the same thing. And it went to the fire department, the state fire marshal, several of the other parties. There's a landlord, there was a property owner, landlord, who's different, person who maintained the property, and then the tenants. And the question that the attorney had was, what caused the fatal fire? Because we're going to go after if it was a light switch, if it was a stove, it was a dryer, we're going to go after whoever caused it. So I had an interesting conversation with him, and he said, this isn't new. And I said, really? I've been practicing. At that time, I've been practicing for 25, 30 years, and I had never heard of it. And he said, no. He says, we did this for the Station nightclub fire as well. That's 100 people died in that fire. And the idea was that when you have a potential stake, and it could be that you want to sue somebody. It could also be that you want to defend yourself. And this is where the fire department could feel a need to do this if they feel that someone is going to damage the evidence. That basically what happens now is the court takes responsibility for the scene. And then if there's going to be any testing, and this is particularly destructive testing, where you're going to test certain components of the electrical system, whatever, that it's done in a way that it preserves the evidence, and that whoever does the testing is not going to be accused of spoliation. Because if you do destructive testing of something and someone who had an interest in it was not involved in that testing, it could be spoliation. So it's an interesting thing. Again, it's not the type of thing where if you're on an engine or ladder or an EMS unit, you really kind of give a crap about it. But it is an interesting thing, and it is relatively rare. But I did a class for this. It was an association of defense attorneys who work for insurance companies, and I lectured at one of their conferences. And just preparing for that, in the insurance world, this is a fairly common practice. And I'm sure Chip, our friend Chip, would probably be up on this, and that it could almost be malpractice for somebody like Chip not to do this in the right situation. So interesting. I thought it was interesting. So
lawyers, a good lawyer will always place a hold on evidence. I have a case now. I wanted to explain this. I have a case now going to trial in January, and we have a portion of video that was recorded at a firehouse camera, and I request the whole video, and the whole video doesn't appear to exist anymore. But one portion of it, right, which the defense views to favor them, seems to exist. So so here's what I've done. I've requested, because I want people to see how this works. I've now subpoenaed under court order the logs of the destruction, the deletion, the accessing, right? I want to see who copied it, who deleted it. Did they just copy it and then allow the rest to be deleted because there should have been preservation? And you're going to get caught. If you play these games, I'm just saying you're going to get caught. Here, I'm going to see those logs, and somebody is going to get caught if they destroyed them. And that's why those logs exist. Your
knowledge of the internet and the way the computers work and the typical types of logs and what information is available in terms of deleting and all that, most attorneys are not going to have that kind of expertise that you have, so that they're in trouble. And that's my point. They're in trouble. They've got the wrong guy at the other end of this lawsuit. So
and by the way, everyone should know there are internet service logs and logs for almost everything. If you're screwing with QuickBooks has a full audit trail, and a lot of software, financial software, has an audit trail, and your internet, anything that connects to a server, has an audit trail. And they don't go away, and it's all public record. A lot of courts have held that the audit trails, right, deletions, accessing recordings, turning on, turning off cameras, all in an audit trail. Don't mess with these. You're going to get caught, is my warning to everybody.